Hi everyone, I'm Attorney Johnson. I focus on cross-border legal issues. Today, I want to talk about the federal appellate decision that could significantly change how US trademark owners sue China-based sellers. A US appellate court recently affirmed a ruling that said you generally cannot serve a China-based defendant simply by emailing the summons and the complaint. For many Chinese cross-border e-commerce merchants, that's a major piece of good news, but for US IP owners, it makes enforcement harder and more expensive. To understand why this matters, we have to look at what's been happening in cross-border e-commerce over the last few years. Platforms like Amazon and others have made it easy for small and mid-sized businesses in China to sell products to US consumers with relatively low overhead. With that huge volume of products, trademark disputes are inevitable. From a US brand owner's perspective, by bringing lawsuits, they have two goals. First, to stop the accused products from being sold on the platform, and second is to try to recover some money, damages, or a settlement. The legal theory itself is not always complicated. The unique feature is the scale. A rights owner can search online and quickly find dozens of storefronts that appear to be using the same trademark or confusingly similar mark, but most of those individual stores doesn't sell massive amounts, maybe a few thousand US dollars or a little bit more, but not enough to justify expensive one-on-one litigation. If a brand owner had to file 50 separate lawsuits to go after 50 different sellers, the legal cost would be far higher than what they could recover from each small seller. So in practice, a high-volume enforcement model developed. Instead of one plaintiff versus one defendant, plaintiffs often file a single case and attach a long list of defendants, sometimes dozens or hundreds at once. This type of case is often called a SAD lawsuit. A lot of these cases have been concentrated in certain federal districts, especially US District Court for the Northern District of Illinois. But here is a key point. The high efficiency of this entire model depends on one procedural step. The service or process must be fast and cheap. In any civil case, you can't just file a complaint and then proceed as if the defendant automatically knows about it. The defendant must be properly served with the summons and the complaint. In the United States, service is mainly the plaintiff's responsibility. The plaintiff has to arrange it, pay for it, and prove it was done correctly. The court usually does not do that work for you. That means the plaintiff naturally pick the fattest and the cheapest method that they can get proved. For years, in these cross-border e-commerce cases, that fast and cheap method has always been email. Plaintiffs obtain email addresses linked to the seller accounts, sometimes from the platform records, and ask the court for permission to serve by email. The legal hook is the Federal Rule of Civil Procedure 4F3, which allows service of defendants in foreign country by other means not prohibited by international agreement as the court orders. Plaintiffs have argued if the judge authorizes email service and no treaty forbids it, then email should be acceptable. The problem is the treaty part, because the United States and China are both parties to the Hague Service Convention, the major international agreement governing service of process abroad in civil and commercial matters. When both countries are Hague Convention members, service generally has to comply with the convention's framework, which typically rules service through official channels, often called the central authority process. In China, that process is formal and slow. It usually involves multiple layers of transmission through government and judicial authorities. It takes time, it costs money, and it is not designed for rapid, massive litigation against dozens of small sellers. And that is exactly why email service becomes so attractive. Without it, many of these cases are no longer economically feasible for plaintiffs, especially when each individual seller's sale volume is not high. Now we get to the decision that caused all the attention. In this case, the trial court, Southern District of New York, held that serving China-based defendants by email violated the Hague Service Convention and therefore did not satisfy FRCP 4F3, and once the service is improper, the case simply cannot proceed. The plaintiffs then appealed, and on December 18th, the US Court of Appeals for the Second Circuit affirmed the lower court. That is why people are calling it a landmark moment. It signals that at least one federal appellate court is drawing a clear line against the routine use of email service on defendants located in China, where the Hague Convention applies. So what does this mean in real business world? It likely increases the cost and time for US right holders to sue China-based sellers, because they may have to use Hague service instead of email. And once you require Hague service, the economics of mass defendant cases change dramatically. From the perspective of US trademark owners, it makes enforcement much more difficult, especially against sellers who can close an old store and easily open a new one. It's also important to understand the geography of US federal courts. This decision comes from the Second Circuit, which covers New York, Connecticut, and Vermont. A lot of high-volume e-commerce IP cases have been filed in other districts, especially in the Seventh Circuit. Whether other circuits will take the exact same approach is something everyone will be watching. But once an appellate court speaks clearly on a procedural issue like this, it tends to influence litigation strategy well beyond the circuit itself, because plaintiffs want predictable and defensible service. Based on what I am already seeing, two practical shifts may happen. First, plaintiffs may become more selective and focus on larger sellers, because only larger sellers can justify the added cost of Hague service and a longer case timeline. And second, US right holders may consider more seriously about enforcing their rights in China. There is a widely recognized principle in civil litigation around the world that you can always sue a defendant where the defendant is located. If the seller and his assets are in China, suing in China can also avoid the difficult question of cross-border judgment enforcement. A Chinese judgment can be easily enforced directly against assets in China, which is often more straightforward than trying to enforce a US judgment abroad. So the big takeaway is this: for years, email service made mass cross-border e-commerce trademark litigation fast and scalable. If email service to China is no longer available in many cases, the model becomes much harder to run at the same scale, and that could reduce the volume of these lawsuits, change how TRO are used, and push rights holders toward more targeted cases or different jurisdictions. I will keep following developments and share updates as the courts and the market respond, and I hope you can follow my channel, and thanks for watching.